going to be learning a lot of more information about what is happening and what might happen with the Supreme Court case that will determine his authority to do this. I can't imagine anyone better, more qualified to talk about this, as well as having an absolutely illustrious career as a juror and judge of international trade, including as a judge at the WTO Appellate Body. Jennifer has been very intimately involved with this case as it came up through the lower courts, including through leading, what did we say, 207 members of House of Senate, of U.S. Congress, and writing an amicus brief challenging the legality of this. So after the seminar, we'll have some time for Q&A.
Yeah, absolutely.
And so please think of your questions as we go, and I will turn over to you, Jennifer.
Fantastic. Great. It is a huge pleasure to be here, arriving on this beautiful sunny day. I'm delighted to be here in Sussex. I've been delighted to be spending the year this year in London, running a program that Georgetown Law started about 18 years ago called the Center for Transnational Legal Studies. So we are really dedicated to trying to make sure that all those budding lawyers out there have some understanding of what it feels like and is like to practice law where everything crosses borders. And so, again, I'm delighted to be here. I wanted to start with just a minute of context in terms of where we find ourselves with these tariffs. And I always like to start by noting that the United States is in this very unusual position, in part because trade, meaning movement of goods and services, plays an actually relatively small role for the United States, about 25% of our GDP involved in imports and exports, compared to, let's say, 96% for the European Union. Ditto if you look at exports. I mean, the United States is not a particularly large exporter, about 11% of our GDP connected to exports, as opposed to China, where it's 20%, or the European Union, where it's 52%. So again, relative to the rest of the world, we're a relatively small trader, but, and here's the big but, because of the size of the US consumption market, when we move on tariffs, when the United States does anything with respect to tariffs or trade, it affects everybody in the world, and very significantly. And obviously what's happened lately has been a huge impact on tariffs. So again, I always like the Financial Times, and a great thank you to them for their, I think, excellent visualizations. What this slide will show you is, kind of where we've ended up in the United States right now with respect to tariffs. Because in the 1 year that Trump has now been in office, he has issued 35 executive orders, 4 memos, and 10 proclamations on trade and tariffs. That is over 16% of every presidential action this year has been focused on tariffs or trade, again, with a huge impact in the United States. So again, if you think back to where we were day one when Trump took office, the average United States tariff was 2.4%. And that 2.4% was actually elevated from where it had been before Trump took office, Trump 1.0, where our average tariff was 1.6%. But during his first term, Trump put a lot of tariffs on China and some on steel and aluminum. As a result, we started at a 2.4% average tariff when he took office. Where are we today? 16.9% average tariff, the highest the United States tariffs have been since 1932. So again, just a huge spike in US tariffs. Again, this is just telling you how it's affected different countries. I mean, you'll see from this chart, the green line is China. So again, the one that's had the highest, in terms of, increase in its tariffs is China. But again, just look at right below it, the EU is number 2 in terms of increase in tariffs. The UK is number 3. So again, you've seen tariffs be spiking, on a lot of, both, if you will, friends and allies, as well as countries like China, with whom the United States has had issues. If you look at what products are subject to these tariffs, again, sort of leading the list is iron, steel, aluminum, et cetera. But then you go down into products that are very much impacting your average consumer. I mean, clothes, shoes, et cetera, are the ones that are now the subject of these, very high tariffs. Again, the other thing that these tariffs have done is, for the first time, these bars are the amount of revenue that we're raising from tariffs. And if you understand how little a role tariffs used to play in the overall collection of taxes, revenues in the United States, minuscule. And now all of a sudden you're seeing this huge spike in the amount of just sheer revenue that's being raised, by these duties. We're now at the level of over $30 billion a month being collected as a result of all of these tariffs. So again, just to say that, the tariffs are, set in this context. So then if we step back and look at, so what has Trump done? This is a pretty busy slide. I apologize for that. You can all have them later. But the bottom line is there have been a number of sets of tariffs, some of them imposed on specific sectors of goods, steel, aluminum, cars, etc., under a different law, Section 232, that is about national security. So we have a whole series of sectoral tariffs applied to specific products. We also have tariffs applied with respect to specific countries, that is largely China, under something called Section 301, a different statute in the United States. And the lion's share of them have been all imposed under the statute that I'm now going to spend the rest of the time talking about, the International Economic Emergency Powers Act, or what I'll call IEEPA. And that's the one that was imposed initially, saying it was being imposed because of fentanyl, the drug fentanyl imports from Canada, Mexico, and China. That was one set of IEEPA tariffs. And then many of you would have seen on April 2nd what Trump refers to as Liberation Day. Don't get me started on what we're being liberated from, but nonetheless, Liberation Day were tariffs, in essence, on everyone in the world as a result of what Trump deemed a national emergency around the trade deficits in the United States. So those worldwide tariffs were, another big source of the IEEPA tariffs, and those are the ones that are the subject of the Supreme Court challenge. There have then been, since then, this entire list of additional actions under IEEPA. So we've now imposed 50% tariffs on Brazil because they had the audacity to prosecute their former president Bolsonaro. We've got tariffs on India because of allegations around purchasing Russian oil. We've got, etc., a whole series of additional IEEPA tariffs beyond those that were in the original set subject to the court. And then we have a whole lot of IEEPA tariffs that have been threatened but not imposed, including, I think very significantly, most recently, the idea of putting 25% tariffs on any country that did not support the United States' takeover of Greenland. And more recently, 100% tariff on Canada because of an objection to what the Canadian Prime Minister Mark Carney said at Davos that was perceived as being not sufficiently in line with Trump's views. We've more recently had a threat to reimpose 25% tariffs on Korea because they haven't swiftly enough adopted the terms of the so-called deal, which we will get to in a minute. So that's kind of where we are, where we have, that's kind of the status quo of where we are right now. So now I'm going to come to the Supreme Court. So the original tariffs on fentanyl and on the worldwide reciprocal tariffs were the subject of two sets of challenges in our courts. And I will say two sets of challenges because for everyone looking at these cases, it was a really difficult question to figure out which court should you file your legal action in? Because the United States has, again, federal courts in every state, in the United States, but it also has a specialized set of courts, the Court of International Trade. And so many people assumed, well, this is tariffs, this is trade, you should file your case in the Court of International Trade. And others sort of looked really carefully at the jurisdictional statute of the Court of International Trade and said, whoa, wait a minute here. Because the Court of International Trade has exclusive jurisdiction over an action, and I'm going to quote, that arises out of any law providing for tariffs for reasons other than raising revenue. So what was the problem for people thinking about, do you want to file in the Court of International Trade, is the fundamental argument that was being made is IEEPA, this statute that I'm referring to, is not a tariff statute. So if you, on the one hand, want to argue IEEPA is not a tariff statute, do you want to be in a court that only has jurisdiction over actions pursuant to a law providing for tariffs. So different plaintiffs made different decisions. So one set of plaintiffs, 12 state attorneys general and a series of small businesses, referred to as VOS selections, they chose to go to the Court of International Trade. Another company, small business called Learning Resources, that makes really excellent children's games and books and puzzles, Learning Resources went to a federal district court. So one court, the federal district court, decided that IEEPA does not provide tariff authority, full stop, right? So they render a decision. The Court of International Trade says, we have jurisdiction because these actions involved a law, the harmonized tariff schedule of the United States, and these tariffs are implicating the harmonized tariff schedule of the United States. Therefore, we have jurisdiction because this was an action taken pursuant to a law providing for tariffs, notwithstanding whatever IEEPA says. And that court decided that the tariffs, reciprocal worldwide tariffs, were a violation of IEEPA because they were way beyond. They were so broad, they applied to every country, every product, et cetera, that they were beyond the scope, if you will, of IEEPA. And the fentanyl tariffs, they decided, were not legal because imposing a tariff on all goods from Canada, Mexico, and China effectively didn't have anything to do with fentanyl imports. I mean, what is putting a tariff on a teddy bear, a t-shirt, or whatever have to do with fentanyl? They're like, no. So that court said no. And then that decision went up on appeal to the Federal Circuit Court of Appeals. And then both of those streams of cases were consolidated into this now one action before the Supreme Court. So what the Supreme Court had before it was two different decisions, both deciding that Trump does not have the authority under IEEPA to do tariffs, but for very different reasons. So now we come to the Supreme Court. All right. So fundamentally, the questions before the Supreme Court, and I think to me, these are really important for the world and for the United States in terms of its separation of powers. I mean, who's got the power to do what in the United States? So fundamentally, the questions before the court were, by enacting IEEPA, did Congress authorize the president to impose tariffs? And that question stems from the fact that under the US Constitution, and again, I'll skip here really quickly. Under the US Constitution, the Congress and the Congress alone have the power to collect taxes and to impose duties. And the Congress alone has the power to regulate commerce with foreign nations. So the president has no authority to impose taxes or tariffs or to regulate commerce with foreign nations, which most people would say trade is commerce with foreign nations. So again, the court had to wrestle with the fact that it's the Congress that has those authorities. And so the question is, when they enacted IEEPA, did the Congress hand over its authority to do tariffs to the president, yes or no? At some level, that's the question. And then the second thing is, if they did do that, is it lawful? I mean, is it a lawful delegation of authority? Because there is in the United States a long-standing notion of a so-called non-delegation doctrine that basically says that the Congress cannot simply hand over its powers to the executive branch without what is referred to as intelligible principles to limit what the executive branch can do, again, particularly if it's a power that the Constitution gives to the Congress. So those were the kind of key questions that really get to this issue of the separation of powers between the executive branch, the Congress, and the judicial branch. But I will say the other issue that was front and center was, even before reaching that, the question was, has IEEPA been lawfully triggered in this instance? I mean, did the president actually meet the prerequisites, in the statute before we even get there? So I'm going to go next to that third question. Because what IEEPA says is, if the president is going to do anything under IEEPA, before he can do any of that, he must declare that there is a national emergency. And that is defined, in the statute as an unusual and extraordinary threat, which has as its source, in whole or substantial part outside of the United States, to the national security, foreign policy, or economy of the United States. So the president has to declare an emergency that says this is an unusual and extraordinary threat to the United States. And then secondly, the statute goes on to say the authorities granted to the president may only be used to deal with that unusual and extraordinary threat and cannot be used for any other purpose. So when you think about it, what the arguments were before the Supreme Court on this issue of whether the prerequisite has been met, on the first question of is there an unusual and extraordinary threat? Again, you have to go back to, let's start with the worldwide reciprocal tariffs. The president's, and the Justice Department argued absolutely yes, because the United States is running this huge trade deficit, and that this is a huge problem for the United States. It has all of these negative effects on the US economy. It's cost jobs, it's hollowed out the Midwest, it's done all of these bad things. And the response from many of the others of us is, what do you mean unusual and extraordinary? The United States has been running a trade deficit every single quarter for 51 years. So how is that unusual or extraordinary if it's a phenomenon that has been occurring for 50 years? What is extraordinary or unusual about that? And if you look at the size of the deficit compared to the GDP of the United States, we're not remotely at an all-time high. I mean, at various points, the United States has hit a deficit that's close to 6% of our GDP. We're now below 3% of our GDP in terms of the size of the trade deficit. So again, a huge argument about what do you mean unusual and extraordinary? How can you say that? And then similarly, with respect to fentanyl, the argument was, we've been importing fentanyl for a whole lot of years. There's a lot of evidence that China had cut back on the amount of precursors it was sending, that Mexico and Canada had cut way back, that the amount of fentanyl coming in from Canada could probably fit into this coffee cup in terms of the amount that they shipped in a single year. Less than 0.2% of all fentanyl was crossing the border from Canada. And in fact, the United States was shipping more fentanyl to Canada than they were to us, etc. So again, why is that an unusual and extraordinary emergency? So there was a lot of arguments on that. And then again, to some degree, the response from the government, the response from the Trump administration was basically, you can't second guess this. If the president says it's an emergency, it's an emergency. And the courts do not have any rights of judicial review. This falls squarely within the foreign policy powers of the president, not subject to judicial review. You are not allowed to render a decision that says we disagree that this is an unusual and extraordinary threat. And the second set of arguments were made with respect to this bottom clause, that you can only use this authority to deal with the threat and for no other purposes. And again, the argument was made very clearly by those opposing this is a tariff on teddy bears and t-shirts does not deal with the fentanyl crisis. It's nothing to do with the fentanyl crisis. So you can't use it for that purpose. And secondly, you keep saying that you're imposing these tariffs. Sometimes it's to raise revenue. Sometimes it's because you want leverage. Sometimes for other reasons. You are not imposing these tariffs to deal with the fentanyl threat if you keep saying all these other reasons. And then with respect to the trade deficit, the argument is, how can you say that you are imposing these tariffs to deal with the trade deficit when, for example, when they were originally announced, the single highest set of these reciprocal tariffs was applied to Lesotho, a little tiny landlocked country in the middle of South Africa, in the middle of the territory of South Africa, got a 50% original tariff. Why? Because they run a trade deficit with the United States. Why? Because Lesotho has a very small amount of diamonds. They happen to have a small diamond mine, and they produce denim fabric. So they ship some stuff to the United States. What do they import from the United States? Almost nothing. Why? The GDP per capita in Lesotho is $2.92 a day. They can't afford to buy anything from the United States. So they don't import very much from the United States. But the notion that you're going to put a 50% duty on Lesotho as though that is going to help them start to import more from the United States as opposed to make them poorer is just, on its face, it's a ridiculous argument. And the tariffs were also applied to countries with whom we run a trade surplus. They were applied to the countries with whom we have free trade agreements, on and on. So the argument was, you failed the test on having the tariffs deal with the emergency that you've declared, even if we accept that the emergency is actually an unusual and extraordinary threat. So again, huge arguments on all of that. The next ones, though, were the more important ones, which is, can you read this statute to be providing this authority to impose tariffs? And the bottom line is, what the statute says is, once the president has invoked a national emergency, and so we'll just say, okay, you met that test, you can only do the following things. And again, the operative language here is regulate importation or exportation. So this raises a whole series of issues. The first one is, can you read the word regulate to mean tariff? Does regulate mean tax? And the arguments that the Justice Department made is, of course it does. It is simply a subset of regulation. I mean, regulation implies a whole lot of activities, but taxing is one way in which you regulate behavior. So of course you have to include the smaller of tariffs within this broader notion of regulate, because regulate can mean block, ban, et cetera, impose conditions, et cetera, and that taxing is just a subset of that, and therefore it must include it, right? That's part of their argument. Their argument is also, this is a very broad statute: investigate, block, direct, compel, nullify, void, prevent, et cetera, that it's a very broad grant of authority, and so clearly tariffs fall within this broad grant of authority. The arguments on the other side were, to some degree, no way. Tariff and taxing authority is completely different from regulatory authority, because when you impose a tariff, the control over whether or not the imports are going to come in or not still rests with the importer. They can choose to pay 100% tariff if that's what the tariff is. They can choose to pay the 25% tariff. If they really want to import the good, they can still import the good. All you've done is made the cost of engaging in a legal activity more expensive, as opposed to when you regulate and you ban, you can't bring it in. No matter what you're prepared to pay, you can't bring it in. It's not okay. And if you violate the regulation, that's deemed illegal activity. So again, the argument was made that regulation and taxing are just not in the same lane. They're very different, right? And therefore, you cannot read this word regulate to mean tax. Secondly, the argument was, whoa, do you really want to go down this road? If you read regulate in this statute to mean tariff, tax, you can now tax all foreign direct investment in the United States, all outbound investment going out of the United States, all financial transactions involving any property that has anything to do with a foreign national, all of a sudden could be subject to taxes. That's a huge grant of taxing authority that, again, the Constitution of the United States would say taxing power belongs to the Congress. And the second argument that was made very loudly by everybody like me on the other side is, just look at this phrase, regulate importation or exportation, and then go back to the Constitution. Oops, I didn't go back, I went forward. Go back to the Constitution that says, unequivocally, no duty or tax shall be laid on articles exported from the United States. So the Constitution says nobody, not the president, not the states, not the Congress, nobody can impose taxes on exports. And yet, if you read this word regulate to mean tax or tariff, it's basically asking the Supreme Court to say, read the word regulate to mean tariff when it applies to imports. Read the word regulate to mean not tariffs when it applies to exports, otherwise it would violate the Constitution. That is just not a normal statutory construction where you can read the exact same word in the exact same phrase in the exact same statute as having diametrically opposite meanings, depending on the word that it's applied to. So again, again, this is one of the things that the court is absolutely going to have to grapple with, is what do they do about this? So in terms of thinking about how is this case going to come out, again, nobody knows. I will say, I've been proven wrong, at least on the timing, because I was hopeful that the court would already have acted on this case, because it came to the court in this very emergency posture. This is an emergency, hurry, speed it up, and the court set a very, very tight briefing schedule for all of us that were involved in this. What do you mean we have to do a brief in 14 days? You know, it was super tight schedule, and a hearing on November the 5th. And again, so people thought maybe we would have an opinion. There have been a number of opinions that have been issued since November 5th. I've looked at all of them, and I do think you can't read too much into the timing. Every decision that have been issued to date have been unanimous, short, not controversial, decisions. This is not going to be short, not controversial, or unanimous. So I think there's a lot of work being done in the courts to try to figure all of this out. So in terms of just thinking about what the possible outcomes are, I think to me, the easiest, clearest, most efficient thing that the court could say is that IEEPA doesn't allow tariffs at all. That you cannot read that phrase regulate importation or exportation to include tariffs. That when the Congress used the word regulate, they did not mean tariffs and taxes because in part of what is referred to in the United States as the major questions doctrine. So this is a doctrine of the Supreme Court that says that when it's an issue that involves a major impact politically or economically in the United States, the Congress has to have clearly spoken when it delegated the authority. And the argument, again, that many of us are making is how can it be clear that this was a delegation of tariff authority when the statute doesn't use the word duty or tariff or tax anywhere in it, where the statute does not have any of the guidelines that are normally in all other trade legislation, like how much can the duty be raised, for how long can the duty be on, which products does the duty apply to, which countries does the duty apply to. In every other trade statute, there is an evidentiary hearing or process in advance to show how, what the impact of the tariff would be. There's an opportunity for anybody that's affected for notice and comment and to show up at the hearings. There's an entire procedure and clear guardrails in all of the other trade statutes. And they all use the word duty or tariff. And they are all codified in the US Code under tariff statutes, under Article 19 of the US Code. IEEPA has none of that, okay? No words, tariff duty, no process, no limits, no guardrails, codified in Chapter 51 of the Code, which is national security, has nothing to do with tariffs. So again, the argument is, this is just not a tariff statute, full stop. And therefore, you should rule that, IEEPA does not allow tariffs. I'm slightly cautiously optimistic that maybe, and this is a low odds that there will be 5 justices that will say that. And that they will say it largely because of this real concern that otherwise you are giving tariff and taxing authority to the president in a way that the Constitution never contemplated. The second thing that the court could say is that IEEPA doesn't allow these tariffs in the same way that the Court of International Trade, in essence, said. Maybe IEEPA could provide some tariff authority, but not these, because these are not limited in time, they're not limited in duration, they're not limited by product, by country. They're not, again, so they could say just these tariffs go too far. Whatever residual tariff authority there may be, these exceed it. And again, because that is what the Court of Appeals for the Federal Circuit said, it's possible that the Supreme Court could simply more or less adopt that reasoning. I personally don't like that reasoning because it doesn't address this export tax issue at all. It just sort of ignores it. But nonetheless, the court could do that. It also could say, okay, no on the worldwide tariffs because they're applied to countries with whom we have a surplus and they're applied worldwide and they go too far, but it would permit the fentanyl tariffs on the theory that there really was an emergency around fentanyl. Fentanyl was killing all these people in the United States, et cetera, et cetera. Or arguably, you could argue vice versa. They could come up with other arguments for why the fentanyl tariffs aren't justified, but the trade deficit ones, trade deficit's a real thing and tariffs are a way of addressing the trade deficit, et cetera. Another thing that the court could do, and again, I put these in sort of order that I personally think are more likely. So I personally think the most likely, or at least maybe it's just my optimism, is that they're going to say no. is let the Congress fix it. You know, if the Congress thinks that they didn't delegate tariff authority here, fine, you've got a couple of options. One is within the IEEPA statute itself. When IEEPA was enacted in 1977, it was enacted with a clause in it that said that if the Congress doesn't like what the president is doing, the Congress can pass a resolution to terminate whatever the emergency is, right? And at the time in 1977, that was perceived as an important check on the president, that you could just declare, nope, we the Congress, and it could be the House or the Senate. The problem is, after IEEPA was enacted in 1977, the Supreme Court subsequently, in a completely unrelated case called Chadha v. INS, decided that that process, to have either the House or the Senate be able to terminate an emergency, constituted an illegal one-house veto, and that you could not have only the House or only the Senate effectively vetoing an action. And so what the Chadha decision basically says is, fine, you can use this language in IEEPA to terminate the emergency, but it requires both the House and the Senate to pass the resolution overriding the emergency by a veto-proof majority, because the president can veto this resolution terminating the emergency, which effectively means forget it. I mean, you know, there's no way. You've already had the Senate pass 3 resolutions terminating the fentanyl emergency, terminating the reciprocal tariff emergency, terminating the Brazil Bolsonaro emergency. So the Senate's passed this. No chance that the House will also pass it and that the president will sign it into law. Not happening, right? So I personally am thinking this idea of let the Congress fix it. I mean, the other thing that the Congress could do could amend the IEEPA statute to make it very clear that it does not include tariffs. Again, what are the chances in our very polar Congress that they're going to, say, Congress pass a law amending the statute? That's your option. So, the last one is that they could declare IEEPA as unconstitutional, that it's too broad of a delegation of authority. Again, remember, we have this non-delegation doctrine where the Congress cannot give up its clear authority without these intelligible principles, these guide rails. Again, I personally think they're not going to go down that road, because if they ultimately declare the entire statute unconstitutional, then the president has no emergency power to impose sanctions on Russia when they invade Ukraine, to impose, sanctions on Iran during the Iran, hostage crisis, et cetera. The president wouldn't have the same emergency authority any longer to do what many people in the United States would say is a legitimate use of this authority when there's a genuine emergency and you need to impose sanctions because of, a specific behavior that is perceived to be more of a threat to the United States. So I personally am not as optimistic I just don't think they're likely to go down that road, but it is certainly an argument before the court. So the last thing I'm going to close on is just kind of what's going to happen if, and I apologize if this is too long. Anyway, so what's going to happen? Again, I'm going to assume, because I do think I give it better than even odds. Again, I'm very involved in listening to the arguments, reading the transcripts 50 times, et cetera, et cetera. I personally think it's still likely that the court is going to say no in some form to the tariffs. Again, there's a lot of other people that disagree with me. Even some of my colleagues at Georgetown, think I'm being that I've started to believe my own arguments, et cetera, that I am not an unbiased judge of this. But I still think the better of the legal arguments are on the side of, and the tenor of the arguments that were there, before the court suggests to me, at least, that I think the court is going to say no. I'll give you just one little anecdote. The lawyer, the Solicitor General, John Sauer, for the government, started arguing that the tariffs fell into this special category that they made up for the first time of a regulatory tariff. They were not revenue tariffs, they were regulatory tariffs, and therefore they were permitted under the statute that says you can regulate imports, that these had nothing to do with raising revenue, that any revenue that was raised was purely incidental, a minor aside, and that the whole focus of this were these regulatory tariffs. literally, as this argument is being made, Trump is tweeting about the billions of dollars that are being raised by these tariffs and how great that is. And there's no question, the justices, I think, saw this as, are you kidding me? You know, that you think you can make this distinction between a regulatory tariff and a revenue tariff, et cetera. Anyway, or that they really believe this, that the Trump administration doesn't care at all about the revenues. They only care about regulating, So assuming the court says no, all right, what's going to happen? My own sense is, as you may have heard, Trump thinks tariffs is the most beautiful word in the dictionary. They will use other authorities to reimpose a lot of these tariffs. And I can maybe skip ahead and say, okay, here, what are these other authorities? If again, I wouldn't want to do this, but if I were in the Trump administration and I wanted to keep these tariffs, one of the things that they could do right out of the box is declare that the United States has a large and serious balance of payments problem and invoke what is referred to as Section 122 of the Tariff Act of 1974 that would allow them to impose a 15% tariff on all imports for up to 150 days. Unless the Congress comes along and extends the tariffs. Zero chance the Congress will do that. The tariffs are very unpopular at home because they're raising prices on everything. But that would buy them 150 days. During that 150 days, they could start what is referred to as Section 301 investigations against all of the countries with whom we have these deals in order to try to say that they're engaging in various practices that are unfair and discriminatory and burden U.S. commerce. And therefore, we need to impose tariffs on every country with whom we have a deal. And at the same time, they could start on the sector side even more of these Section 232 national security investigations against whatever sector of products they think they want to impose duties on. So my sense is, they could do all of that, which would have the effect of largely leaving a lot of the tariffs, albeit capped at 15% in place for a while they do all of these other things. So that's kind of one thing that they could do. The other thing that they're clearly already starting to do, I would say, is to use various other threats to try to bind countries to the deals that have already been agreed upon. These deals where, these countries are alleged to be promising to invest all of this money in the United States and to do a whole lot of other things, right? They can begin new investigations to impose tariffs, as I've just said. I mean, all these other things. And then the last one is the one that, I think a lot of people are worrying about, is they could make the refund process as difficult as possible. If the court rules that the president did not have authority under IEEPA to impose these tariffs, they are under a legal obligation to repay the tariffs that have been collected. And a couple of things just to watch for in that space is, does that mean only repay the tariffs to the named plaintiffs, this learning resources company plus the 12 states, plus these other small businesses, VOS selections, or does that mean everybody? My own view is the statute is pretty clear that they have to refund them to everybody. But again, they could try to make this process, easier or hard. Legally, what would happen is, is again, people would in essence file to reprocess their original customs declarations to say, oh, made a mistake in my customs declaration. I no longer owe this much money. I owe something way less than that. If their entries have not closed out, if their entries have closed out, they have 180 days to file a challenge. The Trump administration could make this easier or they could make it hard. If you file this reclassification, in essence, this redoing, if you will, of your import order, they can say, oh, you forgot a number over here. Oh, you didn't, whatever. Oh, you have to do one for every single entry. You can't do a batch. Oh, you have to, whatever. They could make it very hard. Ask for more information on every entry, et cetera, try to run out the clock, lots of things, or not. So again, there's a lot of things, but there's no question that the whole refund process is going to be huge because at this point, there's been over $100 billion in tariffs that have been collected. So the process of returning $100 billion, and some of it is going to be very, very hard to figure out how you're returning this. Because, for example, some of the tariffs that have now been collected were on what was referred to as de minimis items. So, but prior to these IEEPA tariffs, if you imported a single package on a single day to a single importer that was valued at less than $800, it could enter the United States, what most people refer to as data-free, duty-free, meaning you never paid any duty and you had the most minimal customs declaration, which means everybody that bought stuff on Amazon, for example, the individual consumer might not have known it, but you were the importer of record. It just didn't matter because you didn't have to do an import declaration and you didn't have to pay duty. So you just bought on Amazon. Well, now under IEEPA, Trump has eliminated that de minimis exception. So now every single one of those de minimis imports has had to pay duty. So how do you refund all of those duties? Again, so there's a lot of issues around the duty refund process that's going to be tricky. The other one is what's going to happen to all the deals. Because this list is not even comprehensive. I'm sorry, I pulled this while I was on the train and I didn't have time. So there's even more deals out there than that, because every one of these so-called deals has been imposed basically with kind of a gun to the head of the other trading partners. If you do not agree to this, your IEEPA tariffs are going to be high and or higher than all of your competitors. So again, for a lot of these countries, mostly what they cared about is that their tariffs were not higher than their other competitors. At some level, people just accepted that, okay, if the United States is going to impose a 10% tariff on everybody, I'm okay as long as everybody is paying the 10% tariff. But if anybody gets a lower tariff, I have to get a lower tariff too, or I'm not going to be competitive. So all of these deals are entered into for everybody to try to make sure they're not being, in essence, discriminated against, by these deals. So the question will come, if the court rules that the IEEPA tariffs are not legal, are all these countries going to renege on these deals, renegotiate them, do something else about them? Or do they all think that Trump will simply find all of these other tariff mechanisms, and so they're better off sticking with the deal that they have than being put subject to potentially other tariffs under 232 and 301 and 122 and all of these other things? But again, it's a real open question for what these countries may or may not want to do. And you're already starting, like I said, with respect to Korea and others, the Trump administration start to put pressure on these countries to really finalize these deals, in theory, before the court rules. I mean, they're wanting these deals to be as locked down as they can get them. And the problem is, at this point, none of them have anything resembling binding text. I mean, they're all still at the stage of, press announcements, or sometimes they're sort of MOUs of a general understanding or joint statements, but they are not in any way, shape, or form, as somebody who is the general counsel at USTR, what we would call an agreement. I mean, that has, clear legal obligations, clear binding provisions, clear dispute settlement, clear any of that. None of them have been reduced to that level of detail. And all of them contain these obligations that these countries are going to make investments in the United States. And I use the word obligation very loosely because most of the countries signing on to these agreements, they have no ability to force their companies to make investments in the United States. I mean, so even if the European Union pledges that they're going to make a $600 billion investment in the United States, the European Commission has no ability to enforce that. And when you start looking behind those pledges, what you see is, how did they come up with $600 billion? The European Commission literally went out to the companies in the European Union. Are any of you thinking maybe sometime in the next 10 years you might invest in the United States? Okay, tell us what you're thinking about and how much money would you maybe ever someday invest in the United States? They add up that number and then put it into this deal. Well, so this is again another one of those those last sort of things to watch in terms of, when this court decision comes down, what does it do for the deals? And then, for me, the very last thing that, is always worth saying is that the other problem, at least for people like me with these agreements, is they completely violate our international obligations. Again, so the United States has obligations under Article 1 of the GATT. So again, a binding commitment to all 166 members of the WTO that we will not discriminate on the basis of nationality, but we are charging a 10% tariff on the UK, 15% on the European Union, 50% on India, 50% on Brazil. That is a total MFN violation. We also committed to everybody we would not charge tariffs in excess of our bindings. All of these tariffs are in excess of our bindings. So, I mean, we're totally violating all of our commitments under the WTO. We are totally violating all of our commitments under all of our free trade agreements because we said trade with respect to Canada and Mexico would be free. Trade with respect to Colombia would be free, et cetera, et cetera. Well, 50% tariff, 25% tariff is not free. So we're violating all of those agreements, all of which were enacted by the US Congress. So the Congress has said that the tariffs between the United States and Colombia, the United States and fill in the blank of our free trade part should be zero. And yet we're now charging these tariffs. So they violate all of our international trade obligations, and they violate all of these acts of Congress implementing all of our free trade agreements. So, yeah. So like I said, for me on the US side, I think this is a really, really important decision because of what it says about the relationship between the president's power and the Congress's power, and whether or not the courts are going to stick up for the US Constitution that unequivocally gives that power to the Congress, or whether they're going to bend over backwards to interpret a statute as saying that the president can do this. And then it's a very, very, very broad grant of authority, which will not be cut back. And secondly, again, it would be important for the court to have said, no, you cannot do this because of these international law violations that this IEEPA has allowed. Because again, the IEEPA tariffs are not justified under any, exception to the WTO. There's been no attempt to even argue that they could be justified at the WTO, particularly the discriminatory aspects of them. So again, it's one of those, let's wait and see how the court rules. Again, the next time in theory we could get opinions is the 20th of February. So we'll see. Yeah. There's mud, yeah.
Thank you. So we have just about almost 15 minutes for questions. And if I may, I will kick us off. I mean, I was very struck by the fact that that your most likely scenario was that the Supreme Court will find that IEEPA doesn't permit tariffs, although we take your grain of salt about it. And that strikes me as a way that the Supreme Court is pushing back on the Trump administration in a way that it hasn't done to date. So, so two questions based on that, if I may. The first one, is there a possibility that the Trump administration would just ignore that ruling? And second of all, thinking about the deals,
right?
We have a deal with the US now. Yep. And there is, as you say, a link because that was the reciprocal tariffs brought us to the table. But what is the US legal position if the Supreme Court makes that ruling with respect to the tariff concessions made in, for example, the US UK deal? So would those also be considered IEEPA tariffs? Are those then from the US perspective illegal pursuant to this ruling, or where does that leave the legality of what the US has agreed, for example, with the UK tariff concession?
Let me start with the second one first, because again, the amount of tariff that we charge on UK exports to the United States, again, it doesn't matter that the UK has said it's all right if you charge 10%. There has to be authority in the United States to collect those duties. And if the court says no under IEEPA, unless the president uses some of these other authorities, he doesn't have the right to collect a 10% tariff. So it doesn't matter that the UK said, we'll agree that you're going to charge us 10% tariffs. That doesn't change the fact that, the United States cannot charge a 10% tariff unless there is a legal basis domestically. Because again, you have to go back to who's paying these tariffs. American importers are paying the tariffs. So, I mean, you cannot impose a tax on American importers without lawful authority. So for the UK, it doesn't matter that they've signed an agreement that says that the US tariffs will be 10% if the president doesn't have the authority to do that. And the problem for the UK is they got a better deal than anybody else, so I can understand that they would want to protect that 10% because it's better than every other deal, which is more like 15 or higher. But 10% is a whole lot more than the 2.4% on average that they would be charged without these tariffs. And the other part of the UK deal and a lot of the other deals is that they also include exclusions from these other tariffs that were applied pursuant to Section 232. That meaning the tariffs on autos, auto parts, and steel and aluminum, those are not going to be affected by this IEEPA decision. So those tariffs will still be there. And so to the extent that the deals got you an exclusion from these other very significant tariffs, means the UK may very well want this deal to stay if it gets them out from under these high 232 tariffs. And so, you know, the issue is partly going to be whether the US wants the same deals if it cannot charge the IEEPA tariffs and can only charge the 232 tariffs, and it's given exclusions to a lot of the big trading partners over the 232 tariffs. You know, again, so it's going to really upset the dynamic. On the issue of can the president ignore it, my own view is no. They're going to have to enforce it, because it's not, again, the way it works is the customs service, when the import comes in, has to charge the tariff. Customs service is only allowed to charge a tariff that has been legally, declared as a matter of, US law under customs procedures. So what the court would be ruling if they issue a ruling against the tariffs, is that the proclamations establishing the tariffs are no longer legal. So there's no longer any legal authority for the customs service to charge the tariffs. So I just don't think there's a way for them to not implement it, because again, the importers just don't pay a tariff that they don't owe. I mean, and again, okay, let me just be clear. When the goods come in, goods arrive at a port in the United States, a customs declaration has to be made. I believe this tariff, this product is, a paper cup classified under X schedule. It was imported from Y country. The duty on it is Z, however much that is, $100 duty on this. I pay $100. You are absolutely must release the goods to me. You don't have any other basis to do that. I paid you the $100. Then sometime over the next 351 days, I believe it is, you go through and make sure that, in fact, it really is a paper cup. It really did owe this amount of duty. It really did come from here. $100 really is the right amount. But during that process, customs does not have any authority to do anything other than apply the law. So I think it would be, and again, the level of hue and cry and the number of challenges if they don't. What'll be trickier is if they make the refunds really hard, because then it's just thousands and thousands of lawsuits pending at the Court of International Trade. I mean, the last time we had one of these fights, we had, more than 3,000 plaintiffs in cases before the Court of International Trade. So the refund process could be ugly, but I don't think the going forward process, they would even think that they could charge a duty.
Okay, interesting. All right, I'm sure there's a ton of questions. We only have a short time, so I'm going to take like a few.
Yes, no problem.
So I'll go, is it Bernardo and Beck?
Thanks, Bernardo. It was really interesting. Two quick ones, one political and one a bit more technical. From the conservatives, judges of the Supreme Court, how often have they ruled against the Trump administration? And on the technical side, is it possible, and if so, is it common for the Supreme Court to defer in time or phase in the implementation of a ruling?
Okay, Achit?
Hi, my name is Achit. I'm a legal researcher at the CITP. I have two quick questions. One is essentially that because the section 1701 is the same, more or less like a pared down version of the text of TWEA, and Yoshida interpreted TWEA and upheld that, I agree with your argument that technically could not include tariff, but that same text was allowed to include tariff by Yoshida. So Would it not be made the case that, the same interpretation could be applied here? Also on the same, and the second part is essentially the IEEPA, when it was introduced, it had legislative veto, as you mentioned, and which was overruled later. Couldn't that veto being part of the intelligible principle sort of taking away that element of intelligible principle being there for the non-delegation control being applied?
Yep.
That's my two questions.
Okay, should we take?
Sure, whatever. I can do these. I'll try to be quickly. On the conservatives, by and large, the answer is no, they haven't heavily ruled against Trump, but couple of things that are important. The vast majority of all of the decisions that you've seen, leading up until this case have been decided largely either on what is referred to as a shadow docket, meaning they don't have full hearings, they don't have full briefings. They issue a 1-paragraph opinion that is largely kicking the can down the road, or they have been pure procedural rulings. This is one of the first really hardcore, substantive, on the merits, fully briefed decisions that the court will make. So we don't know for sure. And then secondly, many of the conservative justices are the ones that are the proponents of the major questions doctrine. I mean, they're the ones that are saying, okay, Congress has to have clearly delegated because they did not like what Biden did. You know, Biden forgave student loans and they said, oh, no, that's a major question. You don't have the authority to do that. Biden imposed restrictions on coal-fired power plants under our environmental laws. No, so the conservatives are the proponents of the major questions doctrine. The conservatives are the proponents of this non-delegation doctrine. So they're in a tough position here because the major questions and the non-delegation doctrine go against the president on IEEPA. So that's part of the reason why I think people think that the court will rule against it. Can the Supreme Court defer? They will have to decide this case by the end of the term. So that would be, the latest this decision could come would be the summer. So they can wait until the summer, but they have to decide it within this term. They can't defer it to another time. Yeah.
Sorry, just a quick call back on that. Is deferring the effects of the ruling instead of
No. At least I don't see how they can say you can keep collecting tariffs for another 6 months and then it kicks in. No. If they say no, it's pretty much no immediately. And arguably retroactively, meaning the tariffs were never legal. You never had the authority to collect these tariffs. So you have to refund all the ones that have been collected because they were never lawfully imposed. On the Yoshida question, so just to back up, this IEEPA statute comes out of an older statute called the Trading with the Enemy Act, which was in existence when Richard Nixon was the president of the United States. So under the Trading with the Enemy Act has the same exact language, regulate importation or exportation, that IEEPA does. So Nixon, among other things, took the United States off of the gold standard. When he took the United States off the gold standard, we had huge issues with the dollar all of a sudden starting to float and having huge, massive problems with balance payments. So Nixon imposed a 10% tariff for a limited period of time while he negotiated a series of accords in order to figure out how we were going to deal with the floating dollar. That was challenged. In the original trial court, the court said very much like this: no, this Trading with the Enemy Act, regulate importation, does not provide for imports. In the interim period, then the tariffs were removed because the accords were agreed. The case nonetheless went up on appeal. The Court of Appeals in that instance said, well, these tariffs are very temporary. They're not imposed at a level above what the Congress has already permitted, so they don't violate any congressional provisions. And there's a whole series of other things, and therefore basically we'll let them go. And effectively allowed this term regulate imports to be read as permitting tariffs. And this is unequivocally what the Justice Department has relied on almost exclusively, is Supreme Court, you've already decided this question. It's already been decided. You don't need to think about it because regulate import has already been interpreted to mean tariffs. Now, my own view is there's a lot that you can argue against that. But again, that is their absolute argument, is this has already been a decided question. The courts have already interpreted definitively that regulate imports means tariff. The Trading with the Enemy Act was amended by IEEPA, and in IEEPA, there's no question. The Congress is very clear. We are trying to cut back on, not expand, cut back on the authority under the Trading with the Enemy Act. So you cannot read it as any more expansive. And the court said there were all these restrictions on what Nixon did. So you cannot read now IEEPA to be a more expansive tariff authority. And then secondly, to me, even more important is in 1974. So IEEPA is enacted in 1977. In 1974, the Congress enacted this section 122 that gave the president the authority, if there is a balance of payments problem, to impose this 15% duty for 150 days. In other words, the Congress said, okay, we get it. We see this Nixon determination in Yoshida. We're going to give you that power alone if there is a trade deficit, which to me means you did not leave any residual authority in IEEPA. Now, the Justice Department is arguing just the opposite, that if the Congress did not change the language in IEEPA, it meant that they read in and accepted this tariff authority. I don't think so, because of both the narrowing of the Trading with the Enemy Act and because of the enactment of 122. The Congress clearly said, we've dealt with that problem. We don't need to leave residual tariff authority. Anyway, but that was definitely an argument before the court, and I think may feature, to the extent that there are those that rule in favor of the Trump administration, they will rely on that argument from Yoshida. I'm sorry.
We're out of time. No, it was really, really stimulating. So I think it was February 20th is the next day to watch for this ruling. And I think we'll all have a much more of a toolkit to understand what this means and what the implications might be going forward. So obviously a momentous decision in the US and beyond. So thank you so much, Jennifer.
Oh,
It was
sure. Thanks.
fascinating.